class, welcome to our discussion on the judicial branch of American government. I hope you are doing well and staying safe and healthy during this challenging period. I'd like to make a few comments and make a few points on the judicial branch and highlight some of the key areas that we should be thinking about for this week. Please take a point to regularly check the announcements board, your email, and the Moodle page for the class for regular updates on this class session. So a few things to think about for this week in terms of the judicial branch. As we know, there are 9 judicial officers in the Supreme Court, and the head of the Supreme Court is the Chief Justice of the United States. We also have the foundations of the powers of the judicial branch highlighted in Article 3 of our Constitution. Remember, the Supreme Court was established by an act of Congress in 1789. The judicial branch is the third arm of government, and its powers are enshrined in Article 3 of the Constitution. The judicial branch's function are separate from those of the executive and the legislature. So the judicial branch is key in terms of interpreting the law. And how the judiciary does that, or the Supreme Court does that in our context in the United States, is to tell us what the law is based on a reflection of the law on the Constitution. In other words, is a law constitutional based on how it reflects on the Constitution, or is that law unconstitutional? Based on that, we then have the precedents of judicial review, which we'll be speaking to in a few minutes, which is unique to the US judicial system. In other words, our Supreme Court can reflect a law on the Constitution and determine its constitutionality based on the content of that law and how that law is or can be upheld based on the Constitution, or can be torn down based on that same Constitution. So my point here is to highlight that not all legal systems around the world give their courts this kind of power of judicial review. In the United Kingdom, for example, their courts do not have the extensive powers of our Supreme Court. In other words, in the United Kingdom, the Congress, their version of Congress is their parliament, has the sole power to make law, and courts cannot in and of themselves overturn what their parliament, which is the equivalent of our Congress, has decided. So as we know, the Supreme Court is our highest court of justice in the United States. And there are lower courts, but they are not enumerated in the Constitution. In other words, the Supreme Court is the only court which is specifically written into our Constitution. We have lots of other federal and state courts and court systems, but those are not specifically enumerated or listed in the US Constitution. Judicial review. Courts decide arguments about the meaning of laws and how they are applied and whether they violate the Constitution. And that is what we call judicial review. So judicial review is the process that the judiciary uses to check and balance what the legislature and executive branches have decided. Within the framework of checks and balances, this is an important tool, and it can be seen as a tool of the judiciary in checking the executive and the legislature. Precedent-setting case, 1803, Marbury v. Madison, established the precedent of judicial review. In other words, all other cases heretofrom would draw their legal precedent based on Marbury v. Madison, which was a case decided in 1803. And you can read further on the details and the dynamics of that court as they applied to President James Madison and Thomas Jefferson, who was in line to succeed him, and the narratives around that. But suffice to say, for this class, judicial review is not an enumerated power given to the courts, but is an implied power based off of the precedent of Madison v. Marbury in 1803. The basic characteristics of the court, the judicial branch hears cases that challenge or require interpretation on legislation passed by Congress and signed in by the president. The basics of the court, the Supreme Court is the most visible of the courts, and obviously it's the most powerful of the courts because its decisions have finality. It is not an appellate court. It is a court of original jurisdiction, and cases that are decided in the Supreme Court have the final effect of law. They cannot be challenged in higher courts within the U.S. legal system. And we have a listing of the current Supreme Court justices listed here. Neil Gorsuch, John Roberts, who's the Chief Justice, Kavanaugh, Kagan, Thomas, Sotomayor, Ginsburg, Breyer, and Alito. And John Roberts, who is the Chief Justice, would then lead impeachment proceedings of the president in the Senate. So procedures to impeach a president will be led by the Chief Justice of the U.S. Supreme Court. Take a look at some of the elements of interpreting the law in terms of determining what's legal and what's not legal, the basis of legal interpretations. Judges have to base their decisions on precedents of the law. I spoke to this in some of our earlier classes based on the idea that we need precedent, we need some kind of consistency in terms of how laws are determined. A justice cannot just decide laws based on his or her feelings on a particular day. It has to be based on precedent. So look further then on our dual court system. So we have federal court systems, but we also have state court systems. There are 50 state court systems and one federal court system. The federal court system begins with the district federal courts, and we have the circuit courts of appeal, and then we have the Supreme Court, and we have 50 state court systems, which means each state has its own state court system, which then interprets the law based on the state constitution. Ultimately, within the framework of the supremacy clause, the decisions of the Supreme Court not only apply to the 50 states, but within the framework of the supremacy clause, should there be a challenge or a tension between a state mandate, a state law, and the federal law or the U.S. Constitution, the U.S. Constitution takes precedence. Take a look at some of the state courts. Because this is an American government class, we do not emphasize so much on state court systems. Our main emphasis is on the broader politic of American government, which covers all 50 states. But suffice to say, New York State has its state court systems, as does Florida, Tennessee, California, Oklahoma, and all the other 50 states. So it's a dual system in that we have a federal system, but we also have a state system. Federal courts are in 3 tiers. We have the district courts, circuit courts of appeal, and the Supreme Court. We have cases heard on original jurisdiction, which means the cases originate or start in that court, and cases of appellate jurisdiction, which means The case has already been heard elsewhere and is now being heard on appeal. So this is where the circuit courts of appeal would step in. They'd receive cases from the district courts within the federal system, and they'd be heard in the circuit courts of appeal. And should they be appealed further, those cases would then be heard in the Supreme Court. Thinking about the US Constitution, we have constitutional courts. Judges enjoy lifetime tenure, which means they cannot be removed through political pressure or acts of Congress, but they can vacate office upon retiring or upon a process through the Judicial Service Commission, which would hold them in contempt of their office. They have lifetime of tenure, and since 1869, our court has had 9 members, again an odd number in order to have or to eliminate the possibility of there being a tie. There are 6 members the court needs 6 members in order to have quorum, in order to be able to legally constitute its business. Supreme Court president nominates them, and they have lifetime appointments. Supreme Court chooses its cases. It doesn't take all cases that are brought before it. Take a look at some of the Supreme Court decisions. I posted a link to the Supreme Court on the announcement page of our class, so please take a look at that. We have different types of opinion: majority opinion, concurring opinions, dissenting opinions, and plurality of opinions. So please take a look at those. I am trying to keep this presentation particularly short so that it is a complement to your aside readings rather than a replacement to the assigned readings. Take a look at some of the opinions, the per curiam opinions. These are unsigned decisions of the court that states the facts of the case and the ruling. Majority opinion, which are written the opinion of the majority stating the reasoning for the decision. For example, majority opinion would be a 5-4 opinion, where the majority opinion would be of the 5 justices that agreed to the written opinion. Concurring opinion can be authorized by a justice who agrees with the outcome of the case, but for different reasons. So a justice could agree with a majority decision, but have a concurring opinion because he agrees with the majority based on different reasons. Dissenting opinion is the opposite, where these are highlighted by minority opinions. They're written by justices who dissent, and it may influence future decisions and can also undermine a majority opinion, especially when the vote is very close, like a 5-4 decision. Plurality of opinion: in the absence of a majority opinion, it presents a reasoning of most of the justices who side with the winning party. So again, I wish you good health. Please stay safe. If you have any questions, feel free to email me. Regularly check the announcements page. If I have anything new, I will post it on the announcements page and also on the weekly tab of the Moodle class portal. So again, email me if you have any questions. I wish you a safe week and have a delightful weekend. Thank you.